Good afternoon, everybody, and welcome to today's Law Path webinar. Today, we're going to be going through online and complaining legal must-haves for your e-commerce store. Thank you to everyone who's joined and popped your location in the comments. It's great to have you here. Now, we will be recording this webinar and that will be put on our YouTube channel. So if you do miss any of the slides or you want a recap of any of the information, that will be available shortly on our YouTube channel. I'll introduce our lawyer who will be joining us shortly. Her name is Yien Lo. She's a senior corporate and commercial lawyer at LawPath Legal. She's worked with us for a number of years and has a decade of experience, expertise in corporate structures, governance, M&A, commercial contracts, and regulatory compliance. She has skills in drafting and negotiating contracts, specifically with regards to commercial matters, shareholder and JV matters. She provides clear and actionable advice on all kinds of business and commercial law with a specific focus on privacy, intellectual property, and consumer protections, which is the focus of the webinar today. And it's great for small to medium businesses, even sole traders who are here today looking at starting or maintaining and growing their e-commerce store. She helps with risk management, having the right agreements in place, and then early stage strategic advice, which we do offer through our accelerator program. So the topics we'll cover off today, as mentioned in that consumer law space, we'll cover off on website terms and conditions, what they must include and why. We'll cover off on refunds, returns, and the Australian consumer law, what you can offer, what you can't offer, and how to optimize policies for your business type and product. We'll cover off on privacy policies and data handling obligations under the Australian Privacy Act, privacy principles, and the OAIC. We'll cover off on a platform-specific legal risks that you need to watch out for to ensure that you stay compliant. We'll then go through common e-commerce compliance mistakes and how to avoid them, and lastly, a live Q&A. So if there are any questions, please pop them in the Q&A. We will get through those through the presentation and towards the end. Just a bit about LawPath, what we do and who we are. So we're an online legal platform. We have been in operation for over 10 years now. We recently got some funding from Westpac. So we have helped 500,000 small businesses in Australia. We've saved $500 million in legal fees, and we've garnered over 10,000 five-star reviews. We exist to help small business with their legal, accounting, and tax needs, as well as their compliance in one single platform. So you can get all of your documents, your contract management, such as e-signature. We have a virtual office and asset compliance services, a business registration department, and then a full suite of legal, accounting, and tax solutions. So you can get everything done under one roof for your business. Why this matters and today's topic. So mistakes are public, firstly. Website compliance failures are visible to consumers, regulators, and competitors. The OAIC has announced some reforms that they're going to be kind of looking and doing spot checks to make sure that businesses are compliant with their obligations under the Privacy Act. There are fines and refunds, so non-compliance can trigger refunds, penalties from the regulators, and consumer disputes. So having a really well-written policy that's kind of clear not only prevents matters escalating, it also just spells it out for your customers and avoids other consequences that might come, like chargebacks, and then just protection as well. So to ensure that you're in the right place, having the right documents minimizes risk all round, and ensuring those documents are compliant with the Australian consumer law. A lot of templates, say from AI or free templates online, may be based on US law, and they may not be compliant. So it's good to check that out. So I'll pass it over to Yen, who will kick off today's presentation.
Hi everyone. So let us begin with website terms and conditions. What are they and why do they matter? So website terms can sometimes be overlooked, but they are the legal backbone of how you sell online. Next slide, please. Yeah. At their core, website terms and conditions are your rules for selling or trading online. These are the legal agreement between you and your customers. When properly displayed and accepted, your terms form a binding contract. So that contract governs instances like how orders are placed, how is it accepted, how is it being paid for, delivered, and also resolutions for disputes. They set expectation around key commercial issues, things like pricing, payment timeline, delivery, cancellation, and refunds. Clear expectation reduce misunderstanding and dispute between you and your customers. They also help to limit risk and liabilities, but of course, only in the way the law allows. In Australia, you cannot legally contract out of consumer guarantees as provided for under Australian consumer laws, especially with regards to individual consumers, but you can explain how liability is managed within legal boundaries. Importantly, terms are only enforceable when they are properly displayed and accepted. Hidden terms or terms no one agreed to are very difficult to rely on in a dispute. So, what do I mean by this? If your website terms is not located, for example, in the footers, or if cannot be easily found on main pages of your website, then it will be difficult to argue that the customer has actually agreed to your terms. So what should you include in the terms and conditions? These are the minimum inclusion we expect to see for Australian e-commerce businesses. First, business details. So your terms should clearly identify your legal entity together with its ABN or SCN, not just your brand or trading names, and provide accurate contact information if needed. So secondly, product description and pricing. So this product description and pricing must be accurate. You don't necessarily have to set it out in your terms and condition, but it should be able to be referenced to it. So you can say that, look, the pricing may be subject to change, for example, as displayed on our website. If you reference it correctly, it can be enforceable. Misleading description is one of the fastest way to trigger consumer law issue. And third, order acceptance and cancellation. Terms should explain when an order is accepted and whether and when it can be cancelled. This is especially important whenever there's like a pricing or stock error. Fourth, payment terms and GST. Your terms should clearly explain payment timing and whether GST is included or excluded and whether or not it is payable. Fifth, shipping, delivery, and risk. So shipping terms should address delivery time frame and risk transfer. Ambiguity here often lead to dispute, especially when something goes wrong during transit. Another important one is the limitation of liability. Limitation clauses must be carefully drafted. They can only operate to the extent permitted by the Australian consumer law. So they cannot remove mandatory rights granted under the Australian consumer law. Next slide, please. So this is what the terms cannot do, what your website terms and condition cannot do. So what you can do is that you can explain how refunds are being processed. You can set reasonable timeframes and procedures. You can limit liabilities in lawful manners. You can protect yourself against non-payment or early termination from your client. But what you cannot do is that you cannot state having like a blanket no refund statement under any circumstances. You cannot contract out of Australian consumer law requirements. So for example, stipulate that a 3 months warranty is the sole protection available to your customer. You cannot use it to avoid obligation under the Australian consumer law or the Privacy Act. You cannot use it as a shield for non-performance of your obligation. So the key takeaway is that your website terms and condition is a piece of document that governs your relationship with your customer, and it should clearly explain how their right is being protected and your obligation, their rights. All of these should be clearly set out in the terms and condition. Next slide, please. So now we're moving on to what is usually the higher risk area for e-commerce business: refund, returns, and also consumer guarantees. This is where most dispute arise, where Australian consumer law is most often misunderstood and misapplied. So a misconception I want to clear up straight away is that selling online somehow reduces your legal obligation. It doesn't. Australian consumer law applies to all online sales to Australian consumers. It doesn't matter whether you are selling through your own website, Shopify, Etsy, Amazon, or any other marketplace. It also doesn't really matter how big or small your business is. This obligation exists automatically and they cannot be removed or limited by contract. So under Australian consumer law, customers receive a set of baseline consumer guarantee automatically. They cannot be restricted, removed, or limited, like what I said earlier on. So you don't choose them and the customer do not have to ask for them. Next slide, please. So what are these consumer guarantee? First, acceptable quality. Goods must be of acceptable quality, meaning they must be safe, they must be durable, and free from material defects. This is assessed objectively, taking into account the description and the nature of the products or the goods you sell. Second, the goods must match description. Product must match their description. These include product images, specification, advertising claim, and marketing statement. Third, fit for purpose. If a customer relies on your description or advice or specification about what a product is suitable for or can be used for, the product must actually do that. This is particularly relevant for specialized order or any sort of like technical products. Lastly, service provided with due care. So for services, including digital products and subscription, the law requires that to be delivered with due care and skill and as promised. This applies just as much online as it does offline. Next slide, please. Now we're moving on to the next slide where we'll discuss one of the most asked questions. Do I have to refund my customer? Am I obligated to refund my customer? So refund obligation depends on whether a failure is considered major or minor. This distinction matters a lot. A minor failure is something that can be fixed within reasonable time. In that case, the business generally have the first right to choose to repair, replace, or otherwise remedy the issue. The customer is not automatically entitled to a refund. So a simple example might be you are selling a shirt that has a loose button and it has no other flaws. So it's just a very minor issue that can be easily fixed. What is a major failure then? A major failure is, of course, a more serious issue. It includes situation where the product is unsafe or unusable or cannot be fixed, or if the fixing will take too long. In these cases, the customer chooses the remedy. So the customer is entitled to choose whether they want a refund, replacement, or maybe a compensation. So for major failures, the choice of remedies belong to the customer, not the business. Next slide, please. These slides clear up another misconception. Refund required under Australian consumer law are not the same as change of mind returns. Under the Australian consumer law, if a product is faulty, unsafe, misleading, not fit for purpose, or if your service is not delivered in accordance to what it's promised, a refund may be legally required. Your refund policy, your terms and conditions cannot override this. Change of mind is a different situation. What is a change of mind? So, for example, the customer bought, a skirt that is a wrong size or wrong color, or it found a cheaper alternative somewhere and order by mistake. So these are not considered as failures under Australian consumer law. You are allowed to refuse change of mind refund, but only if your terms and conditions or policy clearly state that. So the key takeaway here is that any refund under the Australian consumer law are mandatory, but change of mind refund can be optional as long as you set it out clearly in your terms. Next slide, please. Again, this is one of the most common area of non-compliance we see. So for store credit, you cannot force store credit instead of a refund where Australian consumer law applies. If a refund is required, it must be a refund of the amount that they paid, not a store credit. Store credit is acceptable for change of mind, but it has to be clearly stated. Oh, I see that there are some questions. I'll address them at the Q&A session towards the end. Yeah. So exchange, moving on to the next one, exchange. Exchange are optional only for change of mind returns. They cannot be replaced, refund for, faulty goods. So of course, a customer, when they receive a wrong size, for example, where the business delivery a wrong size, the customer, of course, can opt for exchange if they want to. So we understand that with all of this exchange or return, it comes at a cost for businesses. So businesses may at times impose fees like restocking fees, admin fees, or delivery fees. So you cannot charge these restocking or admin fees for faulty goods or goods that compel a return due to it being not fit for purpose. But you are entitled to charge these fees for change of mind return as long as it's clearly disclosed in your terms or return policy. Next slide, please. So how are refund and return policy, or how these terms and conditions should be displayed? So refund and return policy should be clearly linked in your website footers. They should be referenced during checkout, not after that. They should be consistent across your website, invoices, and customer emails if they contain this sort of information. and they should be written in plain English so that your customer can easily understand the terms. If the customer cannot easily find your policy or if they cannot find the terms and conditions, then regulator may treat it as misleading. Next slide, please. So what are the common mistakes in e-commerce? So these are some of the issues that we as lawyers see most often in e-commerce businesses. So first of all, of course, is the no refund statement. Blanket statement like no refund are misleading and is not compliant with Australian consumer law. Secondly, hidden refund terms. Refund terms must be disclosed before purchase, not after checkout. So it should be in your website terms or that a link is made available when customer check out so that they can easily click on it and they can easily check what are the refund terms, what can they do if they want to, return an item, for example. Would they be entitled to a refund or whether it would be store credit? And thirdly, confusing platform rules. Marketplace or payment provider rules do not override your legal obligation. If your business is the seller, the responsibility still sits with you. And delayed refund. So delaying refund beyond reasonable time frame escalate dispute and may increase an issues such as chargebacks. And also treating chargeback as optional can lead to frozen fund, higher fees, and also account restriction possibly. So if you remember one thing from this section, it is this: you can control how refunds are being processed, but you cannot opt out from consumer guarantees mandated under Australian consumer law. Clear, compliant refund and return policy protect both your customer and also your business. Now we're moving on to privacy. Next slide, please. So almost all online business collect personal information, often without really thinking about it. And that's where a lot of legal risk can potentially creep in. This section is about what the law actually expects when you collect customer data and where business most commonly get caught out. Next slide, please. So a lot of time people ask, we are a small business. Do we need a privacy policy? So small businesses is defined as a business with an annual turnover of 3 million or less. So these organizations generally are not required to comply with Privacy Act. However, there are exceptions, such as if you collect sensitive information, if you trade personal information, you are a credit collection agency, etc. So you can do a privacy checklist for small business on the Office of the Australian Information Commission website if you want to be sure whether you will be caught under the Act if you're a small business. Nevertheless, even if complying with Privacy Act may not be mandatory for you at this stage, please bear in mind that the government is increasingly scrutinizing the collection of personal information and is looking to remove this 3 million threshold for the Act to be applicable to all businesses, regardless of their size. So there are also other considerations of why businesses may choose to opt in to comply with Privacy Act, such as increasing consumer confidence and gaining trust of your customer. So the question now is, do you collect personal information? What is personal information? Personal information include obvious things like names, email address, contact numbers, but it also include other information like addresses, billing details, or even payment information. So even when a third party like Stripe or PayPal processes the payment, it can also include other information such as website analytics, cookies, tracking pixel, and behavioral data. So if customer can create an account, sign up to emails, receive marketing communication, or complete a checkout from your website, you will be collecting their personal information, and privacy policy is what you can use to set out the rules. It is the Bible that governs the use, disclosure, storage of this personal information your business collects. Next slide, please. So what is your obligation under Privacy Act? At a high level, there are 4 core obligations for online sellers. First, transparency. Customer need to be able to understand what information you collect, how you collect it, why do you need it, what do you use it for. Second, security. You are expected to take reasonable steps to protect customer data from any loss, misuse, or unauthorized access. That doesn't mean you have to impose military-grade system, but you can consider what is the industry norm when implementing a security measure that is suitable for your own business. Third, access and correction. So customers have the right to ask what data you hold of them and have it corrected if it's inaccurate or outdated. And finally, data retention. So while you can keep the customer data, you should not keep them for longer than the period of time you actually need them for your business or for legal purposes. So at a minimum, the customer expect that your privacy policy to clearly explain what type of personal information you collect, how it is collected, to check out forms or cookies, interaction with the site or signing up, and what you use it for. If you use it for direct marketing purposes, you need to disclose it in your privacy policy. You also need to disclose whether this information will be shared with third party, like payment processor, e-commerce platform, marketing tools, and explain how customer can access their data or make a complaint. Next slide, please. Next slide. Yeah. So this slide is where many compliance gaps actually occur. Most online stores don't operate in isolation. They rely on payment gateways, service provider, apps, CRMs, email platform, analytic tools, often dozens of them. So even if a third party handle the data, responsibility doesn't disappear. You're still responsible for how customer data is collected, used, and disclosed, and your privacy policy need to set that out. So if customer data is stored overseas or accessed from overseas, that should be disclosed in your privacy policy. Undisclosed data sharing is one of the most common triggers for privacy complaint, especially when something goes wrong. So one of the most effective way for an online business to scale is through marketing communication with its client or contact database. Marketing emails, SMS, any communication as such require consent and a working unsubscribe function. What this means is that you need to provide an opportunity for these recipients to say, stop, I no longer want to receive marketing communication from your business. What is less obvious, of course, is cookies, tracking pixels, and retarget ads that rely on personal data. If there's any cookies that collect any information, you need to have a clause in your privacy policy disclosing it. The rule of thumb is that if you're using data to track, target, or market to your customer, you need to be upfront about it and set it out in your privacy policy. Next slide, please. So what happened if something goes wrong? Data breaches aren't just technical issue, they can be a legal and reputational risk for your organization. Depending on the circumstances, a breach can trigger mandatory notification obligation, complaint to the Office of Australian Information Commission, and in some cases, account suspension by the platform you rely on, when you sell online. So why is this important? In practice, reputational damage often hurts more than just, it's not just monetary damages, but customer can lose trust quickly, and trust is hard to rebuild. Next slide, please. We are also seeing a real shift in enforcement by the regulator. The Office of Australian Information Commission has begun targeting compliance check starting this January. It began by scrutinizing the privacy policy of businesses that collect information in person. For example, real estate agent asking for phone numbers at open houses, car rental agency presenting customer with lengthy forms. The industry that they are focusing right now include rental property, pharmacies, car rentals, and a few others. So currently, the privacy policy that is non-compliant with the Australian principle can result in compliance notice of fines of up to $66,000. So even small businesses shouldn't assume that they are exempted, especially when sensitive information is involved, or if your industry is not exempted. So we are seeing a shift in how they enforce this. They're doing this enforcement, and we won't be surprised if they will move on to online businesses next. Next slide, please. Next, we'll move on to platform-specific legal consideration. Spotify, Etsy, Squarespace, Marketplace, each one of them create a slightly different legal pressure point. So let's break them down. Platforms are incredibly good at helping you to sell, but they are not taking on your legal risk and responsibility for you. Under the Australian law, you are the legal seller, even if you are using third-party platform. Platform provide infrastructures, payment, checkout flow, listing, but they don't provide tailored legal compliance for your business. If something goes wrong, customer complaints, regulator take action, all of these are directed at you, not the platform. So it's important to remember that platform terms are drafted to protect the platform, not your business. If your store name appears on the receipt, the legal risk lies with you. So let's begin with Shopify. Next slide, please. So with Shopify, you get more control than a marketplace, but that also means more responsibility. The common risk area we see is that Shopify's default template are not tailored to meet Australian law or Australian consumer law obligation. The refund setting can easily conflict with your own refund policy. Legal disclosure can be skipped, buried, or poorly placed, especially on mobile interface. So an app often collect customer data in ways that maybe your privacy policy doesn't cover. So where the problem arises is where in practice customer relies on what they see on screen, not your full policy. We also sometimes see inconsistency between product pages, FAQ, and legal documentation available on Shopify. So any undisclosed third-party data handler are a very common privacy issue with Shopify. So what a good compliance will look like is when there is a custom Australian consumer law compliant terms and refund policy. Check out level visibility of your legal documents, such as your terms of sale, privacy policies. If you have a standalone refund policy, you can include that too. And we will really recommend that you conduct a regular audit of the apps and data collection. Just make sure that from time to time, just do a check and make sure that they actually your terms are aligned, and review their data collection terms to see whether they are in contravention with Australian law or whether there's any issues surrounding that. Next, we're moving on to Etsy. So marketplace like Etsy create a very different risk profile. You get exposure, but in a way you give up control. You often can't really customize your legal terms. The platform messaging can blur who is responsible, whether it's a platform or it's you. Public review can escalate dispute quickly as well. And international buyers introduce cross-border consumer law expectation. So what are the legal risks? The customer assume platform refund rules override Australian consumer law, even though they actually don't. Negative review often escalates straight back and lead to chargeback. And account suspension can happen before disputes are resolved. Sometimes the platform may be too quickly to add on customer complaint, rather and it may lead to account suspension of the seller, and it may take time for you to dispute it and liaise with the platform before you get your account back. So some of the risk management tips include using store description to clearly explain your obligation and set expectation. So you can definitely, insert some of the key terms or the full terms if possible under your store description, especially when it comes to refund terms, exchange terms, that sort of policy. It is very. We will really recommend that you utilize the store description to insert this term. You can also align your policy with platform setting whenever possible, and keep written records of all customer communication. So it's whenever you have any communication with your customer, we will really suggest that you keep a clear record of them, so that because you never know when they actually come in handy. Next slide, please. So Space and website. Standalone website flip the risk profile again, because in this kind of scenario, you have the most control, but also the most responsibility. So typical compliance gap that we see when it comes to a standalone website is that all of these terms and conditions, or refund policies and whatnot, they are not clearly linked. They may not be available at the footers of your website. So it's hard to say when these terms are hidden. It's hard to argue that your customer actually sees them or agree to the terms. So phone collect personal data maybe without privacy disclosure. So why does this matter? Because poor placement weaken enforceability. Like I said earlier on, if they cannot easily find the terms, it's hard to say that, it's hard for you to argue that they have actually agreed to the terms. So one of the most important thing is always place these important terms on a page that is visible. And yeah, you should have consistent refund wording across your site. So do a check, like make sure that your website terms and condition, your refund policy, and also all your communication, be it your customer invoice and whatnot, if they contain any sort of refund policy, make sure that all of these terms are consistent throughout. Next slide, please. Of course, many instances, sellers can sell across multiple channels. So this, again, where seller get caught is really when there are different refund rules on the websites versus marketplace. Because very often at times, for your own website, you may have a refund policy, like a full refund policy of, let's say, 14 days. But let's say if you actually, sell your items on marketplace, for example, on the Iconic, they may have a refund policy of 30 days. And you need to, of course, respect that and abide by it. So yeah, so of course there's also inconsistency, like inconsistency pricing and delivery promises, privacy policies that don't cover every platform being used. So all of it, you should consider what are the platform that you use and do a compliance check on all of these terms. So what are the best practice is that if you can create a core set of legal documents that apply consistently and regularly review compliance as you add on a new sale channel to make sure that there's just no inconsistency between them. So next slide, please. So platform compliance related check. This is what lawyers actually see when things go wrong. Platform may freeze fund during dispute, and chargeback are much harder to defend without clear terms. Regulator expect consistency across all of your sale channel, and very small wording gaps can actually trigger large consequences. Platform help you to sell faster and reach out to a wider audience, but compliance still sit with your business. Next slide, please. Yeah, so let's finish by talking about mistake. So these are some of next slide. Yeah, these are some of the mistake that we see most often. The first one is what we call copy and paste policy and terms. These are the documents that you often some businesses when they are starting off, they may borrow the documents from their competitors, they may adopt it for their use or even from overseas sites. So again, these terms and condition or policies may not be applicable to you or may not be applicable for in the Australian context. If they are not applicable, they are not enforceable. And secondly, no refund clarity, which can sometimes lead to forced refund or ambiguity surrounding who should be refunding what. So third, ignoring privacy. This can often trigger complaint to the regulator for outdated terms. So a lot of time businesses introduce new functions, you may increase like a new channel or new subscription and whatnot, but this may not be reflected in your website terms and condition, and this can cause an issue because if those are not in your website terms and condition, they cannot be enforced. Next slide, please. So how issues usually escalate? It usually starts with a customer complaint about refund or delivery delay, misleading description, or non-compliant data use. If the response is slow or unclear, it escalates to a negative review or even a chargeback. Repeated complaints or inconsistency can trigger regulator inquiry or platform intervention. And at that point, businesses may face legal demands, refund obligation, penalties, or undertakings. So most disputed become big when the foundation are not solid, when you didn't build in the right terms in your policies or in your terms and condition. Next slide, please. So how to stay compliant? One thing I want to be really clear about before we wrap this up is that compliance is not a one-off task. It is not something you tick off when you launch a website or when you launch a business and never revisit it again. The business that stay out of trouble are the one that treat compliance as an ongoing obligation. So first, To stay compliant, you use tailored legal documents. Generic templates, especially the ones that you adopt from overseas jurisdictions, are one of the fastest way to end up with documents that don't actually protect you. Because if they are not applicable, they are not enforceable. Second, review your policy every 6 to 12 months. New product, new platform, new apps, or new marketing methods that you introduce can quickly make your existing document inaccurate or no longer applicable. Third, make sure your website behavior match your wording. So what your website actually does must line up with what your policies say. Regulator and customer can actually look at that, when they decide whether an action should be taken. And fourth, check compliance whenever you scale or so adding a marketplace or launching subscription plan or selling internationally often trigger new legal obligation. And finally, train your teams on all of your policy and keep them updated with your offerings, keep them updated with your refund policies and complaint handling. Even well drafted policy won't help if your staff responds accidentally or contradict to what your policies say, or worse, the Australian consumer law or other applicable law. So the most compliant business build legal check into their regular business operation. They don't wait until something goes wrong, which can be very expensive to remedy. Next slide, please. So I want to finish this with a few key takeaways that I would like everyone to walk away with today. First, online sales are regulated. Selling online doesn't reduce your legal obligation. E-commerce businesses are regulated in the same way as any other businesses and are expected to comply with Australian law, such as the Australian consumer law. Australian consumer law can't be avoided. Refund, returns, and consumer guarantees apply regardless of what your website or the platform says. Third, collecting customer data comes with real responsibility, and this kind of collection are increasingly under the scrutiny of the regulators. So I would say getting support early make a huge difference. Most of the dispute and issue lawyer deals with could have been avoided with clearer documentation and better system put in place upfront. So that's where LawPath can help. We can put in place the right legal documentation so the issue doesn't escalate as your business grows. Yeah. Yeah, with this, I conclude my presentation today. Thank you.
Thank you, Yien. So I just wanted to cover off on some ongoing advice and support for LawPath. As you can see here, we've got 20 lawyers here who work as advisors on our legal advice service and quotation service. So again, they're all experts in different areas. They're all working in the commercial law space, whether that be intellectual property, whether that be offering advice on privacy, as Yien has spoken about, or plenty of other areas. So again, through our legal advice service, you can speak to all of these lawyers on the plan. And then if you do require extra work, like drafting or quotations, that can be addressed by our marketplace service as well. We do have an exclusive webinar offer for everyone on today's presentation. It is 20% off our legal advice plan on the quarterly plan. So you can be billed quarterly instead of paying the full thing up front. There is a coupon code there, LAP Web 20. If you do have any questions about your existing account or you wish to discuss our additional bundle discounts, as well as exploring our accounting and tax services, or if you have an existing LawPath account, just comment yes in the chat. I'd be happy to give you a call, or my team this afternoon. We can go through and give you a demo of the service and how we might be able to help further, and some of our new enhancements on the LawPath AI as well. Awesome. I guess just last, I wanted to really reiterate what Yien was saying on privacy and the ACL. It's a very important area with the OAIC and privacy regulators cracking down. Having a generic policy from ChatGPT or an online website is no longer sufficient. Copying and pasting terms from PayPal or Apple is also no longer sufficient, and that may constitute an intellectual property breach. So it's very important that you do get these matters solved. We have Australian consumer law compliant templates on our website, so refund policies, shipping policies, and everything for an e-commerce store that plugs right into the back of Shopify to ensure that you're compliant. And then we can provide advice for your business setup and maintaining the compliance, as Yien said, every 6 to 12 months through our accelerator program. We go through a privacy screening, make sure that you're up to date with changes in the legislation and your internal processes and policies are being handled. So with all that said, I'll pass it back to Yien for the Q&A.
Okay. Thank you, Ryan. So I can see a few. One of the most asked question is around whether sellers should refund the shipping cost as well. So you don't have to refund the shipping cost if it's so I think so when it comes to change of mind, you can always say that change of mind is subject to a shipping fee of however much you want, like let's say $10. Not however much you want, sorry, a reasonable amount, of course, like say $10. So you can, as long as it's set out in your terms, you can of course deduct that shipping fee from your customer when they return goods. However, if it is the customer actually have to return the goods because maybe they will send a 40 items or item that doesn't meet the description, then of course as business you absorb that shipping fees because it is your mistake to begin with. Okay, let me see. um yeah, so Shane, you have a question about how customer service play into this. So of course your terms or your policy can always be, I would say, be strict in the sense that you only provide refund strictly as necessary under the law. However, as businesses, you exercise discretion. For example, for customer retention purposes, for reputation purposes, you may think that it is more beneficial for your business if you can just provide a full refund, even though that refund may not meet the legal requirement. It doesn't, under your terms and condition, you are not, it's not mandatory for you to provide a refund, but you can of course always exercise your discretion, and sometimes customer appreciate that. Okay, so if whenever you update your privacy policy or your terms, what you can do is, you can always set out when is your privacy policy last updated. So, if you look at privacy policy, you often see that it include a statement, let's say last updated on 1st of January 2026. So whenever you update it, you would just need to, put in a date that it's when it's last updated. And of course, you can always send a communication to all of your customer um, by email, for example, to say that we have made an update to our privacy policy. Please check out the updated privacy policy here and provide the link so that they can easily check on it. So I'm just reading through the questions. Yeah, so for Nick, we can actually help to tailor legal documentation for you. It can be privacy policies or website terms and condition, but we can definitely help to tailor the documentation. So if you need help, just reach out to us after this. Yeah, so Rita, so when offering customized product, I think a lot of times, for this sort of customized product, you also have a specification document. You can set out, how this documentation, sorry, how the product, the specs of this product in a separate specification document. And how you do it is, of course, you may have a website terms and condition, but you can always make reference to your specification document to say that, for example, the product will meet, like, let's say the lead times or whatnot in a separate order form, or when it comes to the spec, it will be set up in the specification. So all of these also provide you with flexibilities, because you may be able to update your your spec from time to time as needed, depending on how it is set out. So Navi, I see that you have a question on providing personal data within AI platform, and whether this must be advised in privacy policy. Yeah, so if you provide personal data within AI platform, you can set it out in your privacy policy that this is one of the way where you disclose your personal data of your customers or users. Okay, so Catherine, you have a question on your site acting as an agent, connecting buyer and seller. So your site is the merchant of record. Does that mean the invoice or whatnot is issued under you, under your site? Okay. So I would say in your terms and condition, you can really set out that your site, you're merely acting as an agent. It is if it's a marketplace, it is a marketplace. But you are not the seller, and you disclaim, of course, your liability in that sense. You set it out clearly that the fulfillment, all the returns or refund will be handled by the seller, not your website. So in terms of the consumer liability, it depends on what is the role played by your website. Whether you are handling, let's say, customer service, maybe you are the one that connect them to the seller whenever an issue escalate. I think for this, if you want to have more detailed discussion, just feel free to reach out to us, because I do need more context in order to advise you in a clearer manner. Yeah. Yeah, so for I think I have answered the question. If you add new third parties to privacy policy, yeah, you just need to you can update your privacy policy anytime. Selling digital product on Etsy, what compliance will you require? So you can actually, for John, it depends on what do you have, but I would say clearly set out your return terms. um you know like your website terms and condition, provide a clear description of the items you are selling, and I think that will be the first step. And yeah, I would also say it would be good if you can just let us know, what kind of digital production that you are selling, and we can guide you on those. Thank you. So what is the best way to for Rita, what's the best way to make clear responsibility when items are damaged? Yeah, so you can let them know, so most of the time, if the item is damaged by, because if you are the one arranging for shipping, you can, of course, you will be the one that have to liaise with the courier or whichever company that's responsible for shipping the goods to your customer. And maybe what you can do is you can set up in your terms that whenever an issue arises, you get ask the customer to reach out to you and give you a reasonable time to investigate and come back with a response to them or a solution for them, because you need some time to actually to speak to your service provider to understand what happened and whether or not it will be real responsibility. And sometimes you can also have an add-on, for example, like an insurance cover in your checkout page, so that customer can also choose if they want to add, for a small fee, to have an insurance so that they can get some sort of they can get the goods sent again to them. This is one of the good way, I would say, to avoid this sort of issue at a small cost to you. So the last question I have here is, what are the privacy concern of retaining customer communication? So it depends on what you mean by retaining customer communication. Is it like a recording, or what is it? So let's say if you will be recording your customers, let's say phone call with your customer, then of course you have to disclose it upfront, by saying that, please note that we will be recording our conversation today for quality improvement or training purposes. Just give a short statement of letting your customer know that you will be recording the conversation and what is that recording for. If you can do that, then it will minimize like any risk surrounding that. But I think if you have other further sort of concern or question around that, just reach out to us and we can answer that for you.
Perfect. Thank you very much for that, Yien. So again, thank you to everyone who has put yes in the chat. We'll definitely reach out this afternoon and give you a call. Otherwise, we very much thank you for attending the presentation today. And this will be available on YouTube along with the slides, so you'll be able to get a full recording of that. So thank you, Yien, and thank you everyone for attending.
Thank you, everyone.